Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users getting folks the answer they need from an employment attorney. Here we have a question from YouTube user Yo-Yo Died, which sounds reminiscent of something. That like Yo-Yo, I don't know what that's a reference to, but it like tickles something in the back of my head that sounds like Yo-Yo Died, so I don't know what that means. And Yo-Yo Dine asks us, what are the advantages and disadvantages of consenting to a magistrate judge in federal discrimination cases? Okay, so the answer is not all that much, but there's a little bit. So two things to keep in mind, and let's just give people a quick rundown on what you're talking about. When you file a case in federal court for workplace discrimination, workplace sexual harassment, sometimes wage claims, you're going to generally be given the option in many federal district court systems to have a magistrate judge, a federal magistrate judge, hear your case instead of a federal judge, like a full federal judge. Now, what is the difference? Federal magistrate judges are the federal judges of the future. They've got all the education, the experience, everything. Like they're going to probably become a federal judge someday. Their situation is different. Their deal is different. They're not as entrenched. But they're roughly the equal of a federal judge in terms of their credentials. Now, how they're not equal to a federal judge is how long they've been on the bench. And that can be a good thing for plaintiffs in two situations. One, they tend to be younger. And younger people have some tendency to be more sympathetic to workplace discrimination, workplace sexual harassment cases than certain folks who are a little bit older. And I'm not, actually would say in many of the federal benches that I've seen, this has actually not been true. So like I'm describing something that I think is probably data driven over the course of the scope of the entire nation, but is not something I have personally experienced anecdotally. So in my personal experience, many of the older judges they've done tremendous work helping and being fair to, not helping. Like they are impartial, right? Nobody's I can think of one instance where a federal judge was like, I would really like to hear this case. Help me help you. Like that happened. And that was like, I can't judge because my client won't let me say what you want me to say. Right? That's the whole debacle. But generally speaking, I have found that in my practice, older judges have not been an obstacle, or at least have rarely been an obstacle to getting my clients the help they need and the victory they need. However, there is some assumption in the industry that younger judges might be better. Younger judges might be more sympathetic to our claims. Well, anecdotally, that has not borne out for my practice and my experience. That is an assumption that people make, and magistrate judges tend to be younger than full federal judges because often full federal judges will sit as a magistrate judge before they become a full federal judge. So they're younger, often. Now, the other advantage, potentially, is that magistrate judges often have a lighter calendar. And that lighter calendar could mean that your case might move faster. It might. No guarantees. I can't even guarantee they're going to have a lighter calendar. They could be really weighed down with tons of other stuff they're doing. But often what you will see with a magistrate judge is that they could have a lighter calendar and they could then be able to move your case quicker, which is usually a good thing for a plaintiff. There's certain situations where you don't. Like if you're limping your case along and you're trying to wait to catch somebody on an IPO when they're going to be in a situation where they really have to resolve litigation and stuff like that, then maybe you don't want to move the case faster. It's rare, but it happens. You can have reasons why, as a plaintiff, you might want a case to move a little slower. It can happen from now and then. It's just generally you want to move as fast as you can. You want to be like full on blitz, just like going for it, like constant pressure, constant aggression, moving the case forward, pushing discovery, pushing depositions, pushing motion practice, appearances. You can have settlement conferences if you want, but we're litigating this right now, right? Like that is often what a good plaintiff's firm will do, and I think correctly, right? So it could be that a magistrate judge would have a lighter calendar, and with that lighter calendar, so then be able to accommodate you being like, yeah, we should do depositions in 3 months. We should like move this. Let's get a scheduling order in place. Let's schedule this back for our next appearance in 3 months. Nice tight discovery schedule, and the magistrate judge would have the bandwidth potentially to be like, okay, and let's do a check-in day to make sure discovery's moving and nobody's just ignoring your demands or anything like that, right? Like it can be an advantage in that way. Beyond those two things, I guess the only other thing I'll say is that magistrate judges are a little less eager to make a law sometimes. So like you'll get some big judicial swings out of some older judges who are well established, who are going to be on the bench for life and everybody knows it, right? Once you're really ensconced as a federal judge, you're a little less worried about getting turned over on appeal. You can say, make a big decision that is a little different than what the law says, and just be like, yeah, I think this is the law now because I put out this case law. And then everybody, all the attorneys will argue like, oh, well, Judge so-and-so decided X in her case, and that case law is controlling now. And like defense counsel's heads will explode because they're like, that's not a legislature. Like that person can't make law. Like, and a magistrate judge is a little bit less likely to do that because they're less established, less entrenched on the bench, more subject to thinking about their career. When a federal judge becomes a federal judge, for most of them, that is the last stop for life, for their career, right? Like, could they go on to be a Supreme Court justice of the United States? Sure, maybe. Probably not, though. Not a lot of those jobs going around, right? Like, it's kind of, they landed, and they did great, and now this is the end, right? And that can make them be more emboldened, right? To do the things they believe are right, or whatever it is that they want to do, right? So, magistrate judges are going to be a little less likely, in my experience, to do wild course corrections in the case law unilaterally. Like, I've decided this is not the law of the land anymore. Must not have been what Congress meant, even though Congress wrote notes saying that this is what they meant. Nothing like a good activist judge, as long as they're helping me. I will bitterly oppose them and their activism when they are harming my clients, right? But it is what it is. Now, anyways, if this was helpful to you, Yo-Yo9, I hope that you like, subscribe, comment down below. Helps our channel to grow. And remember, almost everybody works, but not everybody wins. So, be smart out there.